Hi everyone, we're going to be starting really soon. Thank you for coming to the 10th International Workshop on ADR in collaboration with the Hunt ADR, which will be conducted on a span of 3 days, starting from August 26th to August 28th. Mediate Guru is a social initiative led by members across the globe. The aim of the organization is to bridge the gap between the general public and litigation. We are creating a social awareness campaign for showcasing mediation as the future, having successfully conducted various international webinars promoting alternative dispute resolution, having a reach in more than 100 countries around the world, with an international family growing every day. We thrive to provide you the best lecture series through the best speakers around the globe so that you have a value addition today. I feel very honored to welcome our esteemed speaker for session 2 of the International Workshop, Mr. Gregory Hunt. Mr. Hunt spent 13 years with the Chartered Institute of Arbitrators and its subsidiary IDRS Limited Incorporating, the City Disputes Panel, 7 years at the Center for Effective Dispute Resolution, and 2 years with consumer dispute resolution bodies, including Ombudsman. Mr. Hunt held executive director roles within all organizations and was CEDR's first global group director of dispute resolution. In April 2016, Mr. Hunt formed Hunt ADR, which is registered with the Civil Mediation Council as a mediation provider and a training provider, and is the UK's largest arbitration service provider in incorporating travel arbitration. Mr. Hunt has been involved in at least 120 mediations with parties ranging from individuals to private and public companies, and ranging from no monetary value to £30 million. Thanks you so much to everybody for joining, and without further ado, let us begin. I would request that the speaker begins his presentation, and then those that are viewing can ask their questions in the chat, and we'll have a Q&A session at the end of this.
Thank you very much. With great timing, my monitor has just told me it's going to turn off in 28 seconds. And there's no way for me to do anything but then turn it back on again, but we shouldn't use connection. Thank you very much for inviting me to speak today. As you've heard, my name's Gregory Hunt. I'm the Chief Exec of Hunt ADR Limited. I'm a mediator, a fellow of the Civil Mediation Council. Hunt ADR is a training provider. And we also engage in arbitration services, amongst other things. My monitor's about to turn off, so hopefully you've still got me as I turn it back on again. Yes, great. Energy saving devices, fantastic. Okay, so thank you for the invitation to speak to you today. I'm going to talk to you about how we resolve travel disputes using arbitration and mediation services. So a little bit about Hunt ADR to start with. I established the business in 2016 as a vehicle for me to mediate and to consult on mediation. The business developed, though, in a way I wasn't quite expecting, and now we're an approved mediation provider, a leading arbitration service, and our training and CPD provision is growing all the time as well. In relation to mediation, we're CMC, Civil Mediation Council, certified as a trainer. We're a training partner of several organisations and institutions. We've won many awards in the last 2 years in particular, seem to be winning more awards than ever for our mediation service provision. We provide other training and CPD events for people who have already qualified as mediators. And CERT IDR, the Certificate in International Dispute Resolution, which we did in collaboration with Dr. Kadir Dugal and Rika Rangachari, deals with mediation and arbitration, but in terms of the mediation element, it's largely based on the UK model, and there's a special module within the pack on mandatory mediation provisions across Europe. In relation to arbitration, we're the exclusive provider of arbitration and conciliation services to ABTA, which is the leading travel association here in the UK, and to other bodies as well, both inside and outside of ABTA in lots of different sectors, not just in travel. We're an arbitration service provider. We do ad hoc arbitrations and construction adjudication, where we're an adjudicator nominating body. We provide CPD and training for qualified arbitrators, such as ARBEX, which is the Arbitrator Experience Program, which gives qualified arbitrators the opportunity to actually do some cases, which can be really hard for them once they've qualified. And back to Cert IDR again, with Rika and Kabir. We focus in the main on international arbitration, and we've got special modules covering India, the US, Turkey, and China. In relation to travel disputes, as I've said, we provide ABTA with the arbitration service that deals with disputes between consumers and members of ABTA, so people like TUI, Virgin Holidays, Jet2, Carnival, Hayes and Jarvis, and many others, and some who are not members of ABTA, like On the Beach, Love Holidays, Southall Travel and Dial-A-Flight. And we also develop travel arbitration commercial services, or TACS, which covers commercial disputes in the travel industry as well, and that's using mediation and arbitration. And we just this week were told we've won our first award for travel arbitration, which was the award for leading specialist in travel dispute resolution at the Greater London Enterprise Awards. So most of our awards in the past have been for me or for the business, Hunt ADR. This was the first time we won one specifically for travel arbitration. So that was quite a nice feeling. So looking at travel arbitration for holidaymakers, we overtook operation in May 2018. So we've been doing it for just over 3 years, and we just got another 5-year contract. So we'll be doing it for 8 years by the end of then. And it's to enable holidaymakers to resolve disputes with members of ABTA. It's grown since the scheme was first set up, when it was exclusively for members of ABTA, and we now have other companies who are not members of ABTA signing up as well under the travel arbitration brand. There are 2 separate schemes. I'm going to go through them with you shortly. There's an arbitration scheme, and there's a conciliation stroke mediation scheme. And we've handled, in the last 3 years, we've handled more than 2,500 arbitration cases and over 100 conciliations through this particular scheme. So arbitration, I understand that I'm speaking to an international audience today. The arbitration that we're talking about here is underpinned by the UK Arbitration Act 1996. If a business is in dispute under the Act, arbitration is activated via a contract clause where the parties agree to arbitrate in advance and they're locked into the agreement, or they can elect to arbitrate at a later date if there's no clause in the contract. That's not the case if it's involving a dispute with a consumer. There may be a clause offering arbitration, but it can only be activated if the consumer actually elects to use arbitration. So the consumer can opt into arbitration, and then the business has to use it if the consumer requests it. We govern the rules of the scheme. We limit evidence, we limit cost, and we make things as quickly as possible to make them more attractive than the courts. The arbitrator, again, this is something which is quite often seen as being something specific to the UK, although it is the case in some other countries. The arbitrators are more likely to be experts in the field, not necessarily lawyers. In the UK, you don't have to be a qualified lawyer in order to be an arbitrator. So our arbitrators, we've got about 60 arbitrators now on this particular panel, and they come from lots of different backgrounds. We've got lawyers, we've got scientists, we've got doctors, we've got engineers, surveyors, all the different professions that you would expect on the panel. And probably about 30% are lawyers and 70% come from other professions. The decisions are final and binding and enforceable, of course, under the New York Convention internationally, and it can be much quicker and less expensive than going through the courts, particularly for the holiday makers, which are consumers like you and me. So travel arbitration, unlike other parts of the Hunt ADR business, does have its own website. It has its own point of entry, travelarbitration.co.uk, so please feel free to have a look at that. We've got an FAQs page on there, which we regularly update, and last updated I can see there in July. And basically that's where we ask all the frequently asked questions that people ask us more often than not, and provide some guidance and information as well. You can also get links to the rules of the scheme, guidance notes and information pack as well in there, and also access information about the commercial scheme tax. When a consumer is sent a link, they're sent a unique link, I'll get onto that in a moment, by the travel company, then they come into our portal, and all of the scheme is managed through the portal. Obviously people can speak to administrators as well, and if somebody doesn't have access to the internet or isn't savvy enough to be able to use the internet and able to handle the dispute, then we can do things by post. But 90% plus of all the cases that come through the scheme are dealt with through the portal. And I'm not going to show you the portal today because it will take too long, but the portal takes people through the different stages of the arbitration process, allows them to update their case, allows them to upload any documentations, photographs, video evidence that they might have. So you might have photographs of a dirty pool or a video of a cracked pavement that somebody tripped over or whatever it might be, and they're added to the portal so that they can be shared between the parties. Typical types of claim that we get through the scheme. I just took by random just 10 cases, or might be 11 cases on there off the system this morning. So £210 claim, return of holiday deposit. Just over 4,000, just under £4,000, £4,500. Claimant was requesting cost of additional flight and hotel, taxi transfers, being stranded with no assistance from the reps. £500 for health and safety issues. £1,200, which was the difference between a cancelled holiday and the holiday that they then rebooked with the same tour operator. £1,090 for building work at hotel, no breakfast area, and they claimed it was dangerous to walk out of the hotel. Just under £500 for the fact that part of a cruise was cancelled without notice. There was a dirty balcony on the ship, there was a waste pipe leaking, and a faulty cabin fridge. £3,229 for repatriation, stress, refund of unused flights, refund of a river cruise that didn't take place and was supposed to, £4,027 for a holiday cut short, upgrade which was promised was not given, day was lost due to a hotel move, there were no cafes, restaurants, sea activities, gym, all these things were advertised as being open and weren't. This was pre-COVID, by the way. Safety concerns, stress, time and delay. And in that particular complaint, it was 502 days since the initial complaint was made that the case was with us for arbitration. £4,099, another claimant said it was a total disaster. And then just to show that we get bigger cases as well, because the claimant is £25,000, somebody was requesting £12,000 total refund, as they claimed effectively no beneficial or substantive element of the holiday was provided, only risk and distress. That just gives you a flavour of the types of complaint that we get through. At the moment, a lot of complaints are about the fact that the tour operator has offered a refund for a holiday affected by COVID, but has only offered vouchers when the consumer wants the money back. So we're seeing a lot of cases like that at the moment. Key features of the travel arbitration service itself. Claims must be made within 18 months of the return or planned return date, and the company has to take part if requested by the holidaymaker. So if I'm in dispute with a travel company, I would complain, I would get back, I would complain again, and if it's not resolved, I've got 18 months to take that dispute to arbitration. Of course, the travel company could settle. So they do have the option. They don't have to go to arbitration. They can always settle to keep it away. Claims can be made for up to £25,000, and that's a maximum of £5,000 per person. Okay, so you could have 2 people on the holiday. The maximum claim would be £10,000, not £25,000, because it's £5,000 per person. Personal injury claims can be made under the scheme, but they're limited to £1,500 per person. and they can't make up the majority of the claim. So you can't have more than half of the claim size being because of a personal injury issue. It has to be a less significant part. Only monetary awards can be made. So there's no other types of resolution. It's simply either the claim succeeds or fails, and if it succeeds, then the award will be that the tour operator must pay a certain amount of money to the holidaymaker. There's no other type of solution. The arbitrator, when appointed, considers evidence submitted by the parties and then makes a legally binding award, which must be fully reasoned. Payment of the award is due within 21 days of the date that it's issued by us to the parties. Parties can appeal the award within 14 days under the scheme's own appeal service. And if you appeal, it has to be on the basis that no arbitrator should have reasonably made this decision based on the information that they're being provided. If the appeal is unsuccessful, the parties do retain the right to then go and try and appeal in the courts and seek leave to appeal in the courts, which is incredibly rare. A win is classified as where the holidaymaker is awarded an amount higher than they've been offered before the arbitration, and a loss is where they're awarded an amount equal or less than offered before the arbitration. If the holidaymaker loses, then they're going to be ordered to pay the company an amount equivalent to their own registration fee. So if a claim is for less than £7,500, then the fee the consumer, the holidaymaker, pays is £108, which is £90 plus taxes. So if they were then to lose the case, the arbitrator would order that they have to pay the travel company another £108, plus, £90 plus taxes towards their costs of the arbitration. But that's the limit. They can't be awarded any more costs. Around 70%, this has been the same figure for many years, around 70% of holidaymakers are successful at arbitration, which means that they are awarded more than had been previously offered by the company before they entered into the arbitration process. And if they are successful, they also get built within that a refund of the registration fee that they've paid out. So if I was a consumer and I applied for £5,000 and the company had previously offered me £1,000, and then the arbitrator says you can have £4,000, I'd also have my £108 added to that as part of the award, so I don't have to in effect have paid for the arbitration to take place. So looking at the process in a bit more detail, consumer, who's the holidaymaker, complains at resort that they've got a problem, whatever the problem might be. It either gets fixed or doesn't get fixed at the particular time at the resort. Then they get back from the holiday, they then complain to the tour operator. Again, I'm using the term tour operator, travel agent, airline, whatever it might be. We'll just call them tour operators, so we just give them one name. The tour operator then rejects the application for compensation or whatever it might be. They then tell the consumer that they can go to ABTA. This is clearly for cases where it's a dispute with an ABTA member. It's slightly different for the other cases, but these are the vast majority of cases. They ask ABTA to get involved, and ABTA have an informal conciliation process where they will talk to the parties and try and get them to some sort of resolution. If that's not successful, then they will issue what they call a pre-arbitration notice. And the pre-arbitration notice goes to both parties, asks them for some details about the dispute, and ask them if they can't settle, would they like to elect to go to arbitration. If the consumer says yes, then the tour operator has to take part in the arbitration unless they settle at that point with the consumer. If the pre-arbitration notice comes back and the consumer says, yes, please, I'd like to go to arbitration, then ABTA will issue to them a smart application pack. So they'll send them a version in the post, but they'll also send them a link, which is a unique link linked to their booking reference, which allows them to go into our portal and to make their application. So they'd either submit the link by post or online, and they pay their registration fee at the same time. Okay, so we don't accept an application until the registration fee has been paid. We then send the claim, well, electronically. It's disseminated through the portal to the tour operator, who've got 28 days in which to either submit a defence to the claim or to settle the dispute. If they put a defence in, then we will appoint an arbitrator at the next stage, and they will incur their portion of the fees. If they settle, there are no extra costs in terms of the arbitration. The settlement must include a refund of the consumer's registration fee that they've paid to enter the process. It's very important for the tour operator at this point, when they put their defence in, they have to cover all of the claims that are made in the claim. So they can't miss one out, otherwise it's seen as being accepted. So if there are 10 points to the claim and they only answer 9 of them, then whatever the 10th one was, the arbitrator will take as them saying, yeah, we agree, that one we were wrong, and you should award against us. So they have to be very careful to make sure they defend all the claim. If they don't put a defence in, then the arbitration continues on the claim evidence only. So it is likely, although not 100% certain, that the consumer would win in that particular case because it's not being defended. But the onus of proof is on the consumer. So if the consumer still hasn't proven their claim, even if there's no defence, then there is still a chance that they could lose the arbitration. We invoice the tour operator at this stage, and then we send a copy of the defence, assuming there is one, to the claimant for them to make any comments. This is just giving them an opportunity to say whether they agree or disagree with anything that's been said in the defence, but it's not an opportunity to upload more information, documentation, etc. All that's got to be done in the first instance when they make their claim. A copy of those comments are then sent to the tour operator for a final reply, and again, in their case, the final reply can say nothing more than the consumer has added more information here, or they've added an extra photograph that wasn't in the original claim. So it's just to bring the arbitrators attention to information that they feel has been added at that stage. Then we appoint the arbitrator. So all the way through this process, started 18 months ago, all the way through this process, there's no arbitrator yet. So when we get to this point, we then appoint the arbitrator. And as I said, we've got about 60 on our panel, and they're generally on a cab rank based on their own availability in terms of whether or not they, when they get appointed. And then the arbitrator is given access to all the case details on the portal for that particular case. Okay, so they can see all the different documentation, submissions, etc. that have been made by the parties. The arbitrator can then ask the parties for clarification, ask them for more information, issue directions for the parties to do certain things by certain dates in order to get that information to the arbitrator. And then once the arbitrator's got all of the information that they require, they've then got 28 days to publish their award. Okay, now that generally behind the scenes is 21 days, because a lot of the time we want to monitor the awards before they're published. We monitor them purely to make sure there are no typographical errors, spelling mistakes, mathematical mistakes. We don't take any role in terms of whether the arbitrator has got the decision right or wrong. That's up to the arbitrator. We're just looking for proofing errors before they go out, because there's nothing worse than getting an award and, if you're the claimant, particularly if you've lost, the arbitrator calls you by a different name or gets the sums wrong. So they say you're awarded a particular amount, and then on the next page it works that amount out and it's different. We just need to make sure everything is consistent, and that's why we review or monitor some of the awards before they go out. So the award is legally binding. It's subject to the usual rights to appeal for arbitration, with an added benefit under this particular scheme, that either party can appeal under the scheme on the basis that the award was one which no arbitrator should have reasonably made on the information that the arbitrator has been given. We don't get too many appeals. We probably had about, out of 2,500 cases, I think we've had about 30 that have gone to scheme appeal. And it's about 50-50 in terms of whether the appeal arbitrator has upheld or rejected the appeal. And it just tends to be quite often on the amount that the arbitrator might have awarded as compensation, either being too high or too low. So the appeal arbitrator can uphold the original award, so there's nothing wrong with it, it's perfectly fine as it is. They can amend it, or they can completely reissue the original award in their own name. Depending on what the appeal arbitrator does, the party making the appeal will get a certain amount of their appeal fee back. So, for example, if the appeal arbitrator completely removes the original award and reissues a new one, then the appellant will get their full appeal fee back. Parties do retain their legal right to appeal in the courts, or seek leave to appeal in the courts at a later stage. Within 28 days it is from the date of publication of the award, or from the date of the appeal. So they do retain the right to do that. That's quite an expensive thing to do, and again, incredibly rare. So just now moving on to conciliation. So some key features of the conciliation scheme. Claims must be made within 18 months, again, as they are in arbitration. Major difference, only applies to claims for personal injury or illness. Okay, so it has to be about something to do with personal injury or illness in order for conciliation to take place. Another difference, claims are limited to £10,000. Okay, so in the arbitration scheme, it's £25,000, limited to £5,000 per person. And within that, personal injury claims were limited to £1,500 per person. What we have in the conciliation scheme is claims are limited to £10,000. There's no limit on whether that has to be for one person or two or three. It's just a limit of £10,000. Unlike with arbitration, the company can elect not to take part. So again, if I have a dispute with a travel company and we complete the pre-arbitration notice and I say I'd like to go to conciliation, if that was for arbitration, the company has to come in and take part. If it's conciliation, the company can say, no, we don't want to. Okay, so they're not obliged to take part. The company pay the fee, so it's free of charge for the holidaymaker. So the company picks up the whole fee. And that's quite good in a way, because it means if the company's prepared to go to conciliation, they're paying all the fee. So it normally follows from that they'd be in a mood to be able to negotiate and try and find some sort of settlement, because otherwise they'd be taking part in a process, paying to be part of that process, and then never actually meaning to negotiate. They're just wasting more money. So it's a good sign that they want to take part and elect to do so. Again, unlike arbitration, mediated settlements can be for anything. Just bear with me while I have a sip of water. For those of you listening in India, I can just hear in the other room that England have just taken a wicket in the cricket. So in conciliation, we've had cases where it is money. Okay, so company pays consumer £1,000, £5,000, whatever it might be. We've also had cases where they've paid them a mix between money and vouchers, so money off future holidays as well as cash in the hand at the time. We've had things like, and bear in mind these are agreed between the parties. We've had things like somebody going on a cruise, and part of the settlement was that they were already booked onto another cruise with the same company, so they got upgraded as part of the mediation settlement, and they got lots of points on the loyalty card as well, far more points on the loyalty card than they probably would ever be able to use, and that was part of what they wanted. And part of that holiday was also a stay on resort, in a very nice resort, where again they were upgraded and given the top level sort of accommodation and service that they could get on that particular holiday. So they didn't get any money as such, but they got other bits of creativity as well for that. So arbitration, it's all about money. Conciliation, the settlement can be about just about anything that the parties want to agree on. The process for conciliation is typical. I'm going to work through that with you just in a second. Cases should be closed within 21 days of appointment of conciliator. That largely depends on the parties. Are they going to be available? to speak or to have a video call. It's undertaken by phone and by video call, and it's time limited, so the scheme operates a 3-hour time limitation. The reality is I've done quite a few of these, and the quickest one I did was about 15 minutes, and I would say the average time is about an hour. So if you get one that goes over 3 hours, you just continue with it, because you know that in the round, you know, it sort of equals out. I've never, probably 3 or 4 times, had mediators say, oh, that one went over the 3 hours. They're normally done quite quickly. Settlement rate, very importantly, is 90%. Okay, so it's got a really good settlement rate. And I think part of the reason for that is because when the tour operator elects to take part, and that means that they have to pay the fee for the conciliation, then that means they're in a frame of mind where they want to get a negotiated outcome and for the dispute to be settled. So types of claim that go to conciliation. So just randomly again, 3,200 room conditions contributed to a family illness on holiday. Just under £5,000. Child was injured under the care of the tour operator after being hit by a branch on a sleigh ride. I did that one, and it was a bit sort of very emotional and quite difficult to do, but we did get there. These are claim sizes, by the way, not settlement sizes. £1,300, family suffered sickness and diarrhea attributed to hotels' poor hygiene standards. Now, some of these claims, particularly when it's to do with sickness and diarrhea, are quite often not the fault of the tour operator. And this is where it comes out in the mediation. You know, I can ask the parties, I'm using the term mediation and conciliation interchange here. I can ask the parties questions like, did you go on an excursion during your all-inclusive stay? And excursions aren't covered under the terms, conditions and responsibilities of the tour operator. So if I was to go on a week-long holiday, and then on day 3 I go on a boat trip and I eat seafood and I drink water that's just given to me, it's not out of a bottle or whatever, and then I get a funny stomach, then it's quite possible that it's because of what I had on the boat trip and not something to do with the hotel. And unless I can prove otherwise, I'm not going to win anything if I go to arbitration or the court about that. So these aren't always, just because these claims are made, doesn't always mean it's the responsibility of the tour operator. £1,000 where a barrier on a balcony on a cruise ship gave way, causing somebody to fall from their balcony and have an injury. Fortunately, they didn't fall very far, and the injury wasn't too serious, but even so, that still came through as a mediation. Somebody claimed £3,500 after they said they'd been tossed around like they were in a washing machine on a rail journey. And we get lots of upset stomachs, Cuban pink eye, and other location-specific type diseases. Lots of slips and trips. We had someone once who slipped off as they were getting off the plane, as it had just landed. They tripped off the sort of little rubber thing between the plane and the steps. So literally at the beginning of the holiday, they tripped. And other accidents, normally relatively minor accidents, although we have had some larger ones as well. So the way the conciliation process works, the pre-conciliation part is exactly the same as the pre-arbitration part earlier on. Complaint in the resort, complaint when they get back, deadlock is reached, consumer asks ABTA to get involved, no settlement is reached. ABTA then issue the pre-arbitration notice, and then the tour operator and the consumer elect to use conciliation at that point. And it has to be, remember, it has to be about personal injury, or the vast majority of the claim has to be about personal injury. We then get a conciliation pack. Now, the conciliation pack is the conciliation application form and any information and documentation that the consumer wants the mediator to see. So that could be photographs, it could be video evidence again, it could be lots of letters that have been written to the tour operator and what those replies were. This is just for the eyes of the conciliator. Okay, so it's not like in arbitration, everything gets seen by everybody. This is just for the eyes of the conciliator. Okay, and it'll include how much they paid for the holiday, how many people went, where it was, and then what they want out of the process. And then we'll also get a pack from the tour operator, which they would normally write like a defence, like a legal document or a defence in an arbitration. And again, that's just for our eyes, and they'll say what they believe happened, what they believe their real liability is, and whether or not any offers have been made at this point. We then appoint the conciliator. So we've got, for this particular scheme, about 20 fully qualified mediators who act as conciliators. I've done some of these myself as well. We appoint the conciliator and contact the parties, setting out what the process is and arranging times to speak to each party. We always speak with the consumer first. We don't do conference calls for this particular scheme because it can be really difficult to manage the emotions that are going on if you do it by a conference call or even by a sort of online video like this or Zoom or whatever it might be. So we speak to each party individually. The conciliator will cover what their role is, they'll outline that everything's confidential and without prejudice, make sure the parties have got authority to settle, remind them about the voluntary nature of conciliation, explain the process and explain that settlement, if it's reached, must be in writing. And they do that with both parties and they get the story from both parties. Where it really differs from what I would call a typical mediation is that in, well, I think all the cases I've ever done, and certainly I think this is the same for the other people on the panel, you spend a lot of time with the consumer, listening, you know, understanding, showing empathy about what's happened to them, and it can be really sort of painful to listen to, and giving them an opportunity to unload and get their story out. But when you speak to the tour operator, at that point you're speaking to someone who's just got an amount in mind that what they want to pay in order for this case to settle, and you don't need to do any of that unpacking with them. It's literally, you know, 40-45 minutes with the consumer on a call, and it can be 5 minutes with the tour operator before you've got an offer to take back to the consumer. So it works slightly differently in that way to what I would call a typical mediation, where both parties are getting an equal amount of time from the mediator. We invoice the tour operator for the fee. As I said earlier, it's free for the consumer. They get up to 3 hours of calls plus emails, texts, whatever it might be that they're most comfortable in using, and I've done quite a few where people have said, can you text me, you know, when you hear back from them or whatever it might be. You facilitate a resolution, or if you get to the point as the conciliator where the parties do want to settle but they just can't quite find the right settlement, then we do have the right under the scheme, which is why it's conciliation and not mediation, to make a recommendation to the parties. Okay, and that recommendation will be based on the fact that you, as the conciliator, have got information that the parties don't know about each other's cases, and you can find, you know what the top line and the bottom line in each room is, and you can come up with a recommendation that hopefully will lead the parties to a settlement. That's worked quite well on other schemes we run in building and construction, things like that. It's very rarely used in travel. And I think that's actually because we find, you know, 90% of cases settle anyway without having to make that recommendation. Then at the outcome, if the parties reach a solution or agree to a recommendation, it's drawn up by the conciliator into a settlement agreement, and the settlement agreement is then signed by the parties and it's binding as a contract. If there's no settlement reached, then the consumer can go on to court if they want to. Remember that everything that's taking place in the mediation is confidential and without prejudice, and so they're free to continue and just simply can't refer to what happened within the conciliation process. And then I'm getting short on time, so I'm going to move on to travel arbitration commercial services. Now, this is something we launched a couple of months ago. You know, we are the leading provider of dispute resolution for the travel industry for consumer disputes, but we also do commercial ADR. So we launched tax to be able to say to travel companies, you know, if you do have a commercial dispute, you can use us as well. So this is aimed predominantly at the whole travel industry, and it doesn't have to be a travel related dispute. It just has to be where one at least of the parties is actually in the travel industry. So it could be tour operators, travel agents, maritime and cruise lines, airlines, airports, international and domestic hotels, bed and breakfast, guest houses, sort of Airbnb types. And we have a scheme with a company called Plum Guide, which is like Airbnb, hospitality, theme parks and attractions. And the dispute could be to do with anything. So it could be a dispute between a theme park and a company that's just installed the carpets in the bar. You know, it doesn't have to be a particular travel related dispute. It just needs to have one or more of the parties are in there. We've got very clearly written mediation and arbitration rules and procedures. Very clear, pricing is fixed and transparent, so the parties know what they're going to pay in advance. They mirror in some ways what we do with the consumer schemes, but it's just a bit of a higher level because the amounts in dispute are larger. So the first case that came through this was a dispute between a hotel group and someone who'd done some work for the hotel group. The dispute was £70,000 or £80,000. I mediated that one, and we had, you know, the same sort of mediation process as we would have done in the conciliation, other than the fact to spend more time with both parties. And we had 3 or 4 people from the hotel group from a place in Europe, and we had somebody from the UK representing the company here, and we mediated for about 6 or 7 hours and got a resolution in that particular case. So we try and keep everything as simple as possible. There's no need to complicate things over the top just because it's a business dispute as opposed to being a consumer dispute. And actually, sometimes it works the other way, because you know, many arbitrators have told me over the last 25 years, I find these consumer cases much harder. There's more emotion involved. The sums are lower, but in terms of to an individual rather than a business, the sums are higher. Because, you know, if I, as a business, have a dispute with another business, say for £5,000, then my business should be able to cope with that. But as a consumer, if I have a dispute for £5,000, that's got a lot more meaning to me, and it means a lot more in terms of money at the end of the day. So that's the end of the presentation. I believe if there are any questions, they've been getting stored up. So I'm not sure what happens now. If somebody's going to tell me if there's any questions, or if I go into the chat and have a look for myself. Okay, so I'm going to go through the questions then, if no one's going to tell me otherwise. As opposed to arbitration, mediation is preferred for disputes which do not involve complex questions of law or evidence and hold potential for amicable resolution outside the formal. Sorry, it's moving about as I'm reading it. Resolution outside the formal and rigid. So how true is this statement according to yourself? Mediation is definitely preferred for disputes which hold potential for amicable resolution. In terms of issues relating to the law, I'm not a lawyer. I've got no legal qualifications at all. And when I mediate, I say to the party, they know that before the mediation, because it's part of what I tell them when they select me, is I'm not a lawyer, and I'm not going to be in a position to sit there with them all day and go through vast legal argument. If they want that, then choose someone who's a lawyer. But I think that's actually largely wasting your time on a lot of commercial disputes, because you're there to try and broker a deal and to move forward, and not to sort of spend the whole day looking at the law. Hi, I can see you popped up on the screen now. Do you want me to be quiet?
No, you can keep talking. There were some questions in the chat, so if you wanted to start answering some of those, that would be good. Okay. I don't want to, if I miss anyone out by accident, please contact me. You can contact me on LinkedIn. You can contact me through Mediator Guru. It's just that things are moving down as I'm reading, and so don't be offended if I miss yours. I have a few of them pulled up if you want to start with those. Okay, then, yeah. Someone wanted to know if you could clarify the meaning with the consumer and the conciliation process. Like, is there a physical meeting or can you do it online?
Yeah, it's all done by online or video. So before COVID, it was all done by telephone calls with the parties. Since COVID, we thought, well, you know, everyone else is using Zoom now, so we use Zoom. We've used a couple of other programs as well, but we keep on going back to Zoom at the moment. So it's up to the party. So you quite often find that the travel company is happy to use Zoom, but we're still finding that the consumers are more comfortable if it's done by phone. So it's a mixture of the two.
And then there's a lot of difficulties arising out of the law itself, and one of them is the inclusion of compulsory arbitration in contracts. Do you think this compulsory arbitration is unfair on consumers, or do you think it's beneficial for society?
Well, at the moment in the UK, and I can only really speak in relation to the UK, arbitration isn't compulsory for consumers. It's something which is an option. So it might be in a contract. So if you think of travel, for example, when somebody gets a holiday brochure from a travel agent, at the back of the holiday brochure, it'll say what to do in the event of a dispute, and there'll be an arbitration clause in there. But the arbitration clause will say that it's only active if the consumer elects to use arbitration. So they can't be tied into it. So there is talk about mandatory ADR in the course here now, starting next year, but they've not yet said which sectors they would be in, and what they exactly even mean by what's going to be mandatory and whether it's going to cover consumers in great detail. But certainly at the moment, it's an option for consumers. It's not mandatory.
Okay, and then we have a hypothetical from Arian at the University of Bristol. Suppose the travel dispute which take place in the United States and then the travel agent is in the UK. Which country's rule would you use for the arbitration?
You'd use the, it'd be based on the contract. So we do have cases like that where it might be a travel company that's based in the US, or it could be Sandals, for example, based in the Caribbean. But their contract with UK consumers when they go on holiday is a contract under UK law. So it doesn't matter where in the world the holiday is, or even where the company is based, if the contract states that it's under UK law, and the arbitration would then take place under the auspices of the Arbitration Act here in the UK.
And then I have one more. Is there a difference in the type of claims or claim limit that a company can do?
Sorry, I'm not sure I understand the question.
I don't either.
Let's say yes then.
Okay.
Okay. Any other questions?
I'm not seeing any at the moment. Nope, I think that's all of the questions for right now.
Yeah?
Mm-hmm.
Okay. Well, as I said, if anyone's got any questions, I'm more than happy to answer them. You know, people can contact me through yourselves, or they can contact me. Probably best to find me on LinkedIn, and they can just send me a direct message. I'm more than happy to help wherever I can.
Okay. So moving forward, I want to thank you, Mr. Hunt, for such a great presentation. And then I'd also like to thank all the participants for joining us. And if everyone could please fill out the feedback form and attendance form to receive your certificates, that would be great. Thank you again for joining us. And Mediate Guru is proud to host these arbitration and mediation sessions and certificate courses. They can be accessed at www.mediateguru.com, and more information will be made available in the chat. And if you don't want to miss any updates from Mediate Guru, make sure to follow us on social media and join the WhatsApp group updates set in the chat box. Stay healthy and stay safe. See you all soon.
Thank you.